Good morning. Happy Thursday. Yes, I still need a haircut. So, there's two issues that I want to discuss today. One, where I have sufficient knowledge to opine on it legally, and the other one where I could just use my experience as an attorney to give you a broad overview of generalities. So the first issue I want to talk about is the presumption of innocence. I got several comments over the last I didn't check my comments regularly for a couple days, so over the last maybe week, regarding presumption of innocence and how can the court make you post bond if there's a presumption of innocence? How can the court, hold you over for trial in custody if you don't pay bond, if there's a presumption of innocence? Well, the presumption of innocence is a legal presumption. What that means is that it is a burden shifting presumption, a burden of proof shifting presumption. So in a criminal case, at trial, all of the burden to show that the defendant is guilty is on the state. If the state or the federal government, if the prosecution cannot show beyond a reasonable doubt that the defendant is guilty of the crimes that he's been charged with, then the defendant wins. All of the burden is on the state. That's what presumption of innocence means. The burden is on the state to prove their case. So essentially the defendant can do nothing and still win. And in fact, many cases, not most, but many cases, are decided very quickly into the trial. The prosecution will present its case, and normally at that point, once the prosecution has rested, once the prosecution has presented all of the evidence in its affirmative case, the defense will make a motion to dismiss for failure to prove the case. A motion to dismiss, they didn't prove all the elements, they didn't present all the necessary evidence. Sometimes that's successful. Many times that's successful. Not most, but many times that's a successful motion. And it never hurts to make it, so even if it's pretty apparent that the state has presented evidence sufficient to prove every single element of every single crime, then you still make it, preserve it for appeal, etc., etc., etc. So the presumption of innocence is basically a proof shifting presumption. There's a similar proof shifting presumption in family law. There is a presumption that any property acquired during marriage is community property. It belongs to both parties equally. That is a presumption that shifts the burden of proof to the party who says, actually, no, it's mine, to show sufficient evidence that it was their separate property. Maybe they could do it by showing it was a gift. Maybe they could do it by showing a writing that transmutes the property from community to separate, but it's a burden shifting presumption. That's what a presumption means in the law. It doesn't mean that the state thinks you're innocent. It means that the state, or it doesn't mean the judge has to think you're innocent. It means that the state has to prove that you're guilty. And you could apply this pretty much at all stages of the criminal process. In order to detain you, the cop needs reasonable suspicion. Now, a lot of people think that it's reasonable articulable suspicion. That's something that's been snuck in by the Fifth Circuit. And articulable is in the description, but they don't have to articulate it to the defendant, to the detainee. They have to be able to articulate it to a judge. That's where the articulation comes in. They never have to prove anything to the detainee. All these videos where people are like, what's your reasonable articulable suspicion? The cops don't have to tell you jack squat. They don't have to explain it to you. They don't have to prove it to you. It's a a judge issue. The judge is the one who's going to have to determine whether or not there was reasonable suspicion for the detention. Reasonable suspicion supported by articulable facts that would lead a reasonable officer to believe that crime was afoot, essentially. And then at the arrest stage or the arraignment stage or the grand jury stage, then it shifts from reasonable suspicion up to probable cause. And again, it's the state's burden. The defendant doesn't have to do anything, prove anything, show anything. You can sit there silently. All the burden is on the state. The state has to show that a crime was probably committed and that the defendant probably committed it. And different jurisdictions require that showing differently. Some just have to show that the crime was probably committed. Some have to show that each element of the crime was probably committed. But that's a burden that's on the state. So again, that's how the presumption of innocence works, is it shifts the burden to the state. The state has the entire burden, because if the state fails to show all the necessary elements at the necessary levels of proof at any stage of the proceeding, it's done. So I hope you understand that. It's not like the judge can't order bond, because and think about it. If you're understanding that the presumption of innocence means the judge can't order you to pay bond or else hold you in jail until trial, just think about it. Like, where has that argument ever worked? It has never worked. The judge, if the state has shown probable cause, and there's either going to be a grand jury indictment or a probable cause hearing or something along those lines, your state may vary, but there's going to be some showing to the court to establish that there is in fact probable cause. Somewhere, somehow, a judge has to determine that there's probable cause. I don't care how your state does it, but somewhere, somehow, in that process, a judge or a grand jury has to determine that there's probable cause. And that was the state's burden to prove, and that allows it to proceed to trial. And at trial, it's the state's burden to prove to the judge or jury, depending on if it's a bench trial or a jury trial, that the defendant committed the crime, every element of the crime, beyond a reasonable doubt. So that's the burden of proof. That's the presumption of innocence in a nutshell. If you're trying to apply it anywhere outside of a court setting, anywhere outside of a burden of proof, you're not understanding it and you're doing it wrong. Now, as to the thing that I can only give my general kind of best understanding as a lawyer, is the motion to dismiss in the fraud or troll case, the Denver Metro Audits versus fraud or troll copyright case. Now, again, copyright isn't my stomping ground. I don't care about it enough to actually look into it. I'm doing this as a personal favor to fraud or troll. Now, the analysis that I gave of the complaint was that it was a good workmanlike complaint. Despite my distaste for RSN, it was a workmanlike complaint. It appeared to sufficiently allege all of the elements necessary to support at least a default judgment of copyright infringement. So the motion to dismiss doesn't attack the complaint as far as I think it does suggest that there's insufficient showings of things, but it doesn't attack the complaint as being completely insufficient, failing to allege all the elements. Stepping back, let's talk about the attorney. The attorney that Fraud or Troll hired is a copyright attorney. That's his stomping grounds. That's what he does. That's what he knows. There is a benefit in hiring an attorney that is experienced in a specific field, that does most of their work in a specific field of law, simply because they have an understanding of that particular process, the relevant cases, the relevant statutes, how courts are likely to look at things. And in addition, they probably have a backlog of motions for each specific kind of issue that comes up. So, for example, I'm sure that this motion to dismiss is essentially a carbon copy of a prior motion to dismiss this attorney has done with just the facts of this particular case put in, but the motion itself, I'm sure, is similar. Very similar motions have been filed by this attorney many, many, many times. So he's a good attorney who does this law primarily. And so does that guarantee a win? No. It does, however, make a more fair outcome probable. It decreases the odds of fraud or troll getting an unfair outcome and increases the odds of fraud or troll getting a fair outcome, or maybe even better. So for example, hiring an attorney who knows what he's doing changes you from getting a RC amicus brief to getting a competently written motion to dismiss. It's night and day. You could tell the difference. Like, I will shit on that amicus, that motion to be an amicus by Darcy all day long. It was a shit motion with zero chance of success, poorly written, poorly researched. It was just generally shit. And that doesn't mean that Darcy is a bad attorney. It means that he doesn't know shit from fuck about the kind of law that he was dealing with. He didn't know shit from fuck about amicus briefs. He didn't know shit from fuck about copyright. I mean, like, he might as well have been a pro per. It wasn't handwritten, scrawled across lined paper, but it was essentially like it was shit. It was pure shit. And again, that doesn't mean he's a bad attorney. If you put him in a field he practices in normally with the support of his junior attorneys, he probably does just fine, maybe even great. But in the specific situation he was in, because that's not his stomping grounds, because he doesn't know shit from fuck, it was a terrible, terrible pleading. This attorney, the new attorney, he knows shit from fuck. He wrote a competent, I would dare say good, motion to dismiss. Does that mean it's going to prevail? Well, now, this is pure speculation on my part. This isn't grounded in anything other than speculation. So don't take this as legal advice. Don't take this as some insight from, the same John who looked at like some of the DeCastro stuff and predicted the outcome or other things. Don't read that in. This is just like a wild ass guess. This isn't a scientific wild ass guess. This is just a wild ass guess. My wild ass guess is that the issue that matters is the fair use issue. I mean, he pled 4 different things, but as far as I'm concerned, I think the one that really matters, the one that's the make it or break it, is the fair use. And I have not watched either video. I haven't watched DMA's video. I haven't watched Fraud or Troll's video. So, again, this is a wild ass guess. My best guess is that the court will probably find either that it was not fair use, or that the court is going to leave it to the jury to determine as a matter of fact whether it was fair use. That is my best guess. Assuming the allegations in RSN's complaint, DMA's complaint, are true, that there was only like 2 minutes of content, if I remember correctly, that was added by Fraud or Troll into like 47 minutes of DMA's content, I would have a hard time thinking that a court will find that it's fair use, just as a matter of law. I would have a hard time finding that a court would find as a matter of law that it's fair use. It might be determined by the jury as a matter of fact that it's a fair use, but I would have a hard time finding that as a matter of law on a motion to dismiss that it's fair use. Could it? Sure. I mean, this is just a wild ass guess. The process is most likely the court will watch both videos and make a determination. Again, my wild ass guess is that this isn't going to be the end of that issue. And my best wild ass guess is that now that is that now that Fraud or Troll has a good, competent attorney, that there's going to be a settlement. That's my best wild ass guess. I don't know if DMA is going to be reasonable. I don't know if Fraud or Troll is going to be reasonable, but my best guess is that it's going to be a settlement. So that is my best wild ass guess. Again, this isn't something that I would put any money on, because I don't do copyright law. I don't really care about it. I don't really care about this issue, other than, I mean, it wasn't just Fraud or Troll. Other people asked me to look at it, but yeah. The procedural issues, apparently the attorney for Fraud or Troll failed to file an answer for what's her name, the Fraud or Troll's wife. I don't know if that was the attorney's fault or Fraud or Troll's fault for not indicating that both were hiring the attorney. So, I mean, it's a minor issue. RSN filed for default, which I think was pretty shitty, because a court would set that aside. I mean, like, why even waste the fucking paper? What I would have done as an attorney, if I was in RSN's shoes, is I would have contacted the attorney for Fraud or Troll and ask him, like, are you representing Fraud or Troll's wife as well? Because she was named in the complaint. And, you know, see if he would file an answer then. But, you know, I'm not RSN, and, you know, I don't have much love for him, and I don't have any contact with him anymore, because he was a shitty person, shitty enough to the point where I did not kick him out of my Discord, but I did remove his role so he can no longer participate on the Discord. So, yeah, and I can't say I miss him. You know, and, you know, again, I don't know why people thought I liked RSN. I've never claimed to like RSN. He's a rather distasteful person, as far as I can tell. And it kind of irritated me that people were associating me with him. But yeah. So long story short, Fraud or Troll, I think, has a better attorney than DMA, and is therefore more likely to get a better outcome than he otherwise would have. That doesn't mean that he's going to prevail, because the best attorney in the world can't guarantee victory. The facts are the facts. All the best attorney in the world can do is try to convince the judge to view the facts from a more favorable position than the court may otherwise have done. But the facts are still the facts, and the law is still the law. And so, again, my best guess is that whatever result that is achieved from this is going to be the most fair result that Fraud or Troll can get, if that makes any sense. Anyway, thank you for watching. I'm done for rambling for now. Again, the copyright stuff doesn't really interest me. If I get enough people asking me to talk about it, this is the best you're going to get. It's just wild ass guesses. But yeah, I pretty much only make videos on things that I find interesting, and questions or issues raised in my comments that I think might benefit a large percentage of my audience, or of my potential audience. I mean, the people who are raising the issues of the presumption of innocence watch my videos, apparently, so maybe they'll see this, right? Anyway, that's all I got for you today. Thanks for watching. Have a great day.